It doesn't feel good. It's scary. It's a lot of uncertainty and challenging times for many people, all of us in some way, and some people really challenging. So I'm really glad you joined us, because with COVID reminding us there's really so much we can't control and that we don't like and we wish we could control. So doing what we can to control the things we can is really important for peace of mind, for helping things go as smoothly as possible. If you or your loved ones get COVID or any other number of things happen that tend to happen in life, being prepared for the unexpected is makes it go much smoother, is what we have seen. So we're glad you're here. We want to help you protect yourselves and your loved ones. And so we're going to show a picture of this is most of our team. I want to add that 2 people are on the call today, Gabrielle, who you can see right now, and Dawn, who you'll see later. And they both work with new clients or potential clients who want to learn more about our services and how we can help them. And so they're not in this picture because we're waiting for our new photographer pictures to come. But this is others on our team here. And we do help families protect what's most important to them. We want to empower you to protect yourself, your loved ones, and your hard-earned money. That is basically everything we do falls under that. And so that's why I'm glad you're here. So internet searches for estate planning were up 40% in March of 2020, and they remain at high levels because estate planning is one of those things you can do to protect your family. And so this is a good time to be here. So we're going to start with one piece of it, how your will may be failing you. And I'm excited you're here because 75% of Americans do not have a complete updated plan. People have different pieces of it, et cetera, but they don't have the whole thing. And it's not complete and up to date. So we would love to help you. Just by being here helps. We're going to tell you some steps you can do for free and offer some free resources. The best free resource, and I think a couple people online have already taken advantage of this, is our Life and Legacy session, which is confidential, complimentary, one-on-one session to answer your questions and help you be educated and empowered to make the best decision for you. So you can take some steps today that are no charge to help you start getting ahead of 75% of people. I have a personal story about what motivates me to help you. I will never forget how I woke up on Monday, March 10th, 1997. For one thing, March 10th is my mom's birthday, but the phone rang about 6 a.m. In those days, I had to run down the stairs to answer the phone. So as I was running down the stairs, my heart was beating fast. I was stressed. I thought, there's an emergency of some kind. I wonder who it is or what happened. So as soon as I answered the phone, I heard my sister-in-law Barb's voice. She's the sister of my first husband, Joe, and Joe and I were divorced. So when I heard her voice, I knew something bad had happened to Joe. And I don't know if you've ever gotten a call like that, and you know how it feels. So Barb said, Margaret, I don't know how to tell you this, but Joey died in a car accident last night. Well, I was stunned. It was like just getting hit in the chest. He was 39 years old. It was completely unexpected. And it really just knocked the wind out of me. But I quickly had to get myself together because I had to tell my kids that their dad died. And so I did do that. And here's pictures of them at that age. Ben was 11. That's Ben, who works at our firm now. And Monica was 9. It almost makes me tear up again. And so I had to wake them up and tell them. And I knew it would be hardest for my son because he was 11. He was a boy. He lived to see his dad as much as he could. And his cry of anguish was heartbreaking to me. I'll never forget it. And so as we moved forward, walking through the days and weeks and months and years, I just really walked them through their grief and sadness, which is completely understandable. And of course, there's still some sadness for them today. However, it was all made worse because of Joe's estate plan. And there were two problems with it. And I have to say, first of all, he had an estate plan. He was 39 years old. A lot of people don't. And it was good in a lot of ways, but two key problems. It was drafted by an attorney who was his divorce attorney. It was not an estate planning attorney. So when he did the prenuptial agreement, he had it signed improperly. Just the signing. The document was fine. It wasn't executed properly. And the second thing was he was separated from his second wife, and he hadn't updated his documents for the fact that they were heading toward divorce. So those two facts, which is really common, that kind of thing happens, it made it to be a very litigious or a big fight, let's say. And it was a court fight that lasted 7 years. It went to the Minnesota Supreme Court. And it was difficult. I shielded my children as much as I could, but they knew what was going on. They knew it took years to get their belongings from their dad's house, and it was very difficult for everybody. Now, if Joe had come to Safe Harbor and done the smooth sailing system that I created to address these problems, a lot of this could have been avoided. There may have been some contention because of the divorce pending and things like that, but we would have saved at least over $100,000 of attorney's fees and just all the heartache of 7 years. As my son says, basically my growing up from middle school through high school, this was hanging over his head in a way. And so we really want to help you avoid that. And that's why I created the smooth sailing system, to create a custom, comprehensive plan that's easy to keep up to date, that is really going to protect you and get what you want and avoid unnecessary contention. So I don't have time, to go through the whole smooth sailing system today, but we're going to be teaching you some things to get you started in that direction. And then again, we'll offer you free resources, including the life and legacy session at the end. So what does it matter if you don't have an updated plan? Well, this is why I say it matters. It's your loved ones and your family. Think about them. This is me and my husband. We got married 3 years ago, John, and these are my 3 kids with spouses. And so Ben is on the far left, I think, as you look at it, and Monica on the far right with her husband, Harrison. And people do ask on how they turned out, and they turned out wonderfully. And so I'm very thankful for that. But these are the people I don't want to leave a mess for. And because I'm in a blended family, my husband has 3 sons with wives and children. And I'm concerned about them too. And so that's why I work on keeping my plan up to date. And that's what I encourage you to do. It can be hard to work on an estate plan, but I think if you remember, it's really something you do mainly for your loved ones to not leave a mess behind. It can motivate you to take the next step, whatever that might be. Okay, I just want to tell you a little bit about me, and this will be in the handout that we email to you, but I have years of experience, personal experience. I've shared some of training skills and what I'm really passionate about. So I'm very thankful I can do this job. My siblings and I work together to support my dad, who died last year, and now my mom in this especially hard time with the COVID lockdown she's under. And because of that and other experiences I have, I can relate to my clients, and I really want to help you sleep better at night, knowing you've done all you can to protect yourself and your loved ones. Oh, Jody, you can't hear me yet? Can you hear me yet? I'm not sure. Do you have any tips on ways you could hear us? You could put it in the chat if you think of anything. I'm not sure either. I started my firm 7 years ago. These are just some credentials. I have good reviews on Google and Avo. A year ago, we won the Law Firm 500 to be the 16th fastest growing law firm in the whole country and Canada, actually. And the new award's going to come out for this year. And I'm sure we're not going to be as high as 16, but we'll be up there. And then I'm really involved in a variety of elder bar activities and estate planning, the legal community, Christian Legal Society. So there's just some of my credentials so that you know that I know what I'm talking about, because it is really important to find an attorney who specializes in estate planning. So let's do a roadmap now of where we're going to go today. First of all, We're going to talk about 3 ways your will may be failing you. Then we're going to have time for questions. Feel free to put them in the chat in the meantime. If I can answer, I will, but otherwise we'll do it at that time. And then we'll go over the free resource. Okay, so how your will may be failing you. A will does not avoid probate. So most people think, well, I have a will, I won't have probate. So wills are designed for probate. That's the surprise. Can you avoid probate with a will? Sometimes you can, but it is not automatic. It's really the opposite of what most people think. It's designed for probate. And what is probate? Probate is the court process that gets the assets from your estate to other people. Because when you die, you can't take it with you, right? We all know that. So where's it going to go? How does it get from me to my kids or me to my husband? It's through probate, generally. That is the court process of handling that. And it will go according to your will if you have one, or your trust. And if not, it goes according to the law. Then the law gets to decide who gets it. That's all probate really is. It's a hassle, it's expensive, people don't like it, but that's what it is. So I want to go over the pros and cons of a will versus a trust, because this is such a common question. So if you have just a will with no trust, you should be able to get the assets to the right people most of the time. This is if things are titled right and the beneficiaries are right, which we help you with as part of the smooth sailing system. The money should go where it's supposed to go if you have a will. And it's less expensive because it's less work to create. They're shorter. They're not as flexible. They're more basic, so they're cheaper. The cons is that a probate is likely. If you take advantage of the life and legacy session with us, we can tell you in your case, gosh, it's really likely you'll have a probate. You really can't avoid it. Or we might say, you have a better than average chance of avoiding probate. We can kind of give you a feel for that because it depends on your situation. But in most situations, it's pretty likely to have a probate. Probate cost, we think you should estimate about $5,000 at least for a probate. There's court fees, you have to publish it in the newspaper. There's attorney's fees, a bunch of paperwork and notices that have to be given. Time-consuming hassles. What we hear from loved ones is this is what they really don't like about probate, is the hassles. I mean, we take the burden off people as much as we can, but it's still kind of a hassle. It's public. So like I mentioned, there's public notices. It is a public record. People can go online and see that there is a probate file. They can get the documents and find out how much was in the estate, where the money went, etc. Public. And people don't always like that. You may have heard that you can do a transfer on death deed and a will and avoid probate. Well, this is sometimes true, okay, but not always. So they're not a panacea that is always the perfect thing for each client. An example of where a transfer and death deed wouldn't work is, let's say I transferred my house to my son when I died, my son and daughter, but my son predeceased me. And then his share would really go to his wife. And I didn't want it to go to his wife. I wanted to go in trust for my grandkids. Like, even if I love his wife like I do and I trust her, I really want it in trust for the grandkids. She'll still benefit, but it's for them. And so then it wouldn't work. Or like I have a minor daughter, that won't work. If you had like my 3 kids and my husband's 3 kids, like that's not really a good idea to leave it to 6 different people. There's so many things that can go wrong. So transfer and death deeds can work, but there's risks. So those are the pros and cons of a will. The other big choice you have when you're doing an estate plan is, should I do a revocable trust? And a revocable trust would be, it's actually in addition to the will, but the revocable trust will be the main operating document that runs your estate. And it's like a basket. That's why the basket's there. We're going to put all your assets in the basket, some now, some after you die. And the basket has some rules about who gets to control the money and how it's controlled and what can be done with it. And it just provides a great deal of flexibility and protection. So some of the pros are, you should be able to avoid probate with a trust. And we work with you to make sure the assets get in the basket so that, I think I said the wrong word, you can avoid probate. Second is private. That's because you don't have to go to probate. It's not going to be public record who gets your money or how much you had. It's great for incapacity. Most of us Americans will lose capacity at some point before we die. It could be temporary, it could be permanent, but then we'll need someone else to handle our money. And you can use a power of attorney. You might have heard of that, but banks can really give powers of attorney a hard time and not accept them. This happened to my own mom in financial institutions. Also, they're more limited and they're not as flexible, the power of attorney. So the trustee has a great deal of flexibility. They don't get challenged as trustee. It can work very smoothly. Highly recommended for incapacity. It can also allow you to protect assets when you go on medical assistance. So assets go where you want, just like a will would normally do too. It minimizes your taxable estate. If you have over $3 million in your estate, then in Minnesota, you're subject to taxes. And who knows if that number will change in the future. That's the current number. And you can get protection from creditors, divorce, bad financial decisions, lots of protections for your heirs and for you. The cons is it costs more to draft. It costs less than a probate, but it's more than a will. And it takes a little more time because when you put your checking account in the trust, you might have to move automatic payments. And we just want to be upfront about that. So that's a lot of information. If you do the life and legacy session, we can kind of tailor it and tell you based on your goals and concerns, what are the pros and cons for you. And I think that usually helps people a lot with their decision making. So this is our first action step. And we're going to email this to you afterwards. Gabrielle will send you a navigation plan. And we provide this to all of our clients after the signing of estate plan documents. And it's just, I think about 6 pages long, and it's just different instructions, like who has my healthcare directive, where to find documents, who's my financial advisor and attorney, a little bit about what I want when I die, or things like that. So if you take the time to fill that out, that will be really helpful to your loved ones and keep it in a place where they'll find it. So filling that out, making it available to your loved ones is a good first step. This is a client, just gave a little testimonial to us recently, and some of the highlights are she thought our staff was friendly, thorough, and easy to navigate the estate planning process. That is my goal, to try to make it simple for you. And she said that the peace of mind was worth it, knowing that everything was correct. So, and we had good communication, which we also really work on to really make it smoother for our clients. And better, not just in the short run, but in the long run, that you won't have an expensive and messy probate like my husband did, even though he had this estate plan. We're taking the long-term view. Okay, next is number 2. Your assets may not go where you want. This is a surprise for people. Like, I got my documents. Aren't I set? No. Your documents need to be ready, and then your assets need to line up with them. And this is where, with the smooth sailing system, we really work to make that happen. And honestly, there's some attorneys out there, and it's suspected, they get your documents in order, but they don't work on your assets because they want the work on the probate when you die. And I don't think that's right. So we really work with you to get it all together and support you after the signing to get things in place. So in order to explain this, I want to, I first want to tell you a story. Let's see. You can go to the next slide. I had 2 brothers. Well, let me tell you about the sisters the 4 sisters came last summer, I think. Their mom had died, and actually only 2 of the sisters came in, because what happened is one sister died 2 months before the mom, and one died 1 month after. I mean, it was terrible. They were young when they died. And so there was a CD at a large bank in town, and it said, to my 4 daughters in equal shares per stirpes, which means, they each get 1/4. And if one predeceases, it goes to her kids. But there was fine print, they found out. And the fine print said, if your child dies before you, they get 0. And if your child dies after you, they still get their share. It goes to their kids. So this first daughter got cut out just because she died before the mom. And that wasn't what the mom wanted. And that is not what the beneficiary designation said. But the policy that went with the CD said it. The other similar case I had was two brothers, and one brother hired me. So his dad had a checking account and a savings account. He didn't have a lot. He made one son joint on checking, one on savings. You know, mine was joint on the savings, I think. And then he named the brother personal representative to handle the estate. Well, the brother paid all the bills out of my client's account. He didn't share it equally. He paid it all out of my client's account. So when my client hired me, he was getting nothing, and his brother was getting like 20,000. And so we worked with him and we negotiated with him, and we got him, I can't remember what, a few thousand, not half of it, because I said we can go to court and get half of it, but it'll probably cost you more. And he just didn't want to fight with his brother anymore. I don't blame him, but he'll never talk to his brother again, probably. And that I do not think was what the dad wanted. He wanted it to be even. And with a trust, it would have been even. But the way he was doing it with the beneficiary designations on the will opened it up for the brother to take more money. So those are two examples about both cases. The will was fine. And actually the beneficiary designations were what they wanted, but it didn't work out the way they wanted. So think about this. Remember, we said you can't take it with you. So how do your assets transfer from one person to another? Probate isn't the only way. So the first way is what I talked about, beneficiary designations, which I'm sure you've all done. Okay, Jody can see here, good. Titling of assets is the other. So like you own your house probably jointly with your spouse. When you die, they're going to own it. I mean, there's a little paperwork involved, but they're going to own it pretty automatically. Both of those are fairly automatic. There's just a little paperwork after death. The next two are not so automatic. Either with a will, which often goes through probate, probably, or a revocable trust. Either way, there's going to be a person in charge. For the will, it's called personal representative. For the trust, it's called trustee. And they're going to like put on their hat and pay all the bills, collect all the money, and pay it out to whoever it says. That's how the assets get out of your name into, hopefully, the people you want them to go to. So I'm giving you a lot of information. I'm trying not to overwhelm you. But so in this section, there's a couple things I just want you to remember. That beneficiaries and joint ownership both trump the will, because the man who said, his will said, I want everything to go to my two sons divided equally 50-50. But because of how he had the accounts, it didn't go that way, because the beneficiaries trumped the will and the joint ownership. And same with the woman with the 4 daughters, the beneficiary trumped her will, said everything went equally 4 ways, and they trumped it. So as part of our job, we always advise and help you to make sure those beneficiaries and joint ownerships are going to work with your plan. So here's my next action step you can take by yourself for free. It's going to help you, your loved ones, if something happens to you. If you hire an estate plan attorney, it's going to help them. And we prepare this for our clients ourselves, but you could get started. We'll send you an asset summary form, and you're going to be putting down my assets, what bank it's at, say, who owns it, is it joint or not, how much money is in there. And then you could put on there like who's the beneficiary. And that would be very useful to keep track of all your assets and really know what you have. I think you'll find a lot of our clients find they have more money than they think to protect. So here's another estate planning client who was very pleased with us. They thought our information was understandable and helpful as they think through the details. And we weren't condescending. That's great. And they were not overwhelmed with legal statements. So they were glad they chose us, and we were really glad to work with them. And that's really typical. We really strive to help people have a pleasant experience and be relieved when they're done. The third way your will may be failing you is it does nothing for incapacity. Wills only help you when you die, right? They don't do anything till you die. I had a friend say, my will is working out just fine. I'm like, well, you're still alive. I mean, we don't really know. But anyway, also before you die, most of us have a good chance of losing capacity, and then we can't handle our affairs temporarily or permanently. And the will's no help. You might hear living will. I mean, that's an old name for a healthcare directive or an advanced directive, and those do help. But that's not what I'm talking about. I'm talking about your will and your testamentary will. So let's see. Okay. If making decisions about the kind of healthcare you get is important to you, you'll want to pay attention. I mean, think about COVID. Think about if you want to be on a respirator. I mean, these are big decisions. And who do you want making the decisions? This is really important. So if you want a say in what happens when you can't speak up for yourself, it's really important to have this paperwork ahead of time. So I want to take you back to, oh my gosh, probably 5 or 6 years ago. Pete called me, not his real name, and said my wife was diagnosed with dementia. They were both about 60. About a year ago. And gosh, I've been meaning to get an estate in order, but there's been so much going on. I'm still working and we're trying to figure so much out. And I just haven't done it. And now she took a turn for the worse. We took her to the doctors last week and they confirmed like she kind of nosedived in her capacity and I'm going to have to retire and take care of her. And oh my gosh, I hope she can still sign estate planning documents. And I said, you know, I hope she can too, you know, because I knew if she couldn't, we'd have to go to court and have him appointed her guardian. It would be really expensive and really a hassle. And so we made an appointment and then he called me and said, I can't put her through it. She went through all these grueling tests. I can't put her through another test. And I said, oh, you know, I don't give her a test. I just talk to her. She won't know that I'm evaluating her capacity. And I thought, well, if he doesn't want to bring her in my office to talk to me, I really don't want to put her on the witness stand in court. I mean, how traumatic for her. So he did actually come in alone first. And then he came back, he saw it was safe and he brought her. And fast forward like 2 weeks later, they're in my office. Their daughter was there too. They signed their documents. We got everything in order. It worked out. She was able to sign. So what made the difference for Pete? I mean, he was so stressed out and beating himself up for not doing this sooner. And now they were all happy and relieved. And it was because he picked up the phone and made the call and did the smooth sailing system. It made all the difference. I know it can be hard to make that call, but I encourage you to do it before it's iffy, because that is definitely more stressful for everybody. Okay, so yep. Let's see. So part of the smooth sailing system for every adult, everyone over 18 needs this. Is to make sure you have a few documents in place. So let me go over those. The first is, like I mentioned, the healthcare directive. And it's very important you appoint people. And I encourage you to appoint 2 backups for all these documents so that they will last as long as possible. And you're going to name people who will follow your wishes and make your decisions for you if you can't. And so that is really important. And there's been a change to Minnesota law. It was August 2016. Now it's 4 years ago. But in all of the free healthcare directives, I do not see any provision for this. And this is the story. If you lose capacity and your doctor wants to adjust or start giving you any kind of treatment that affects your mental health, like antidepressant or anti-anxiety, you have to have it spelled out in the healthcare directive, witnessed by 2 witnesses, not a notary, in order for your healthcare agent to have the authority to make those decisions. Otherwise, the agent has to go to court for a civil commitment, which no one has ever wanted yet of our clients. So it's really important. And my dad never had anxiety, but his Alzheimer's gave him anxiety. And it was really important to us that he have those meds at the end and be able to adjust them so he was comfortable. So that is something, if you don't have that in your healthcare directive, I really recommend it. The next important document is power of attorney. This gives the other person that you appoint authority to handle your finances and legal matters. And they're important that they be filled out properly and they have the powers you want and the reporting you want. And so that is really important. That form was new in, I think, 2014, and the most common form that's used. But I think it's important to have somebody help you fill it out properly. We do see people come in with problems on those. Then the third one you probably have never heard of. It's digital asset authorization. This was created in 2016 also by the Rufata Act, passed in Minnesota and swept across the country. And what happened is a couple sent their 18-year-old son to the U of M, and he took his finals that first fall. He was 18, I said, and he went to an ugly Christmas sweater party. He left about 11. They found him the next day. He froze to death about 2 a.m. by the river. They don't know what happened. His phone was laying on the ground. They wanted his records. They wanted to know his last communications. They wanted to see his photo. You know, everything was precious to them, not only for knowing how he died and what happened, but also just to have the sentimental value of them. And so even though they owned the phone, they paid for the phone, they paid for the laptop. It was on his plan, the dad's plan. They were not allowed to access his records because they did not have authority, and he was 18. So they were part of the big push in Minnesota. If you want your loved ones to access your digital assets, you know, your information before you die or after, you need this form signed. And we always include that. So those are the three big forms that should be in your incapacity plan that your will doesn't cover. And here's a client, her mom moved up from Florida. And so she needed updated documents because she changed states, and we looked at what she needed. And I love this quote too. She didn't feel like it was a typical lawyer's office. She felt like she was with friends and wanted to make sure we had everything correct. Let's go to the next slide. Thank you for your questions. And how do you move out from being stressed out to having your ducks in a row? Because like I said, I'd like you to put your head on the pillow at night peacefully and know that you've done everything you can. So everything I shared is helpful for you being prepared for the future. But you probably figured out we're scratching the surface here. That's what we have to do. So the one-on-one life and legacy session would be the most helpful thing. Our goal is to educate and empower you to figure out what's best for you and to answer your questions. So if you want to take it to the next level, this is what I recommend. I know this topic is important to you because you took time today to be here, and I really appreciate that. And so you have a chance to come in and meet with Dawn. And why don't you come on over, Dawn? Dawn is right here. Dawn Thompson, she is our client relations manager. It's right up there.
Hi, it's nice to see you all or meet you all here virtually. Love to speak with you all. Look forward to hearing from you.
Thank you.
You're welcome.
Okay, and your picture's on the next page too.
Yeah.
So, so Dawn will take the time to listen to your story, ask about your goals, your situation. It's all confidential. Don't worry, because we will only ask things we need to know that are helpful for us. And then we can really coach you on what are pros and cons for your situation, answer questions, empower you to decide what's right for you. That's the whole goal. And again, I guess we're probably doing most things over Zoom right now, especially this first meeting, but we can do it however you want. And so in order to sign up, there's two different ways. We're available. You can talk to Dawn now. And if you just want to put it in the chat or let us know, she'll call you. I think if we don't have your phone number though, we'll need it because we get your emails when you sign up for Zoom. So that's easy. The schedule does book up, but she has set aside times for you guys because we have found that it's important to do it shortly after this meeting, because I know I talk fast, even though I try not to. And it's a lot. And if it's fresher in your mind, it's less overwhelming. And we've just noticed that people find it helpful. So we always save times. And so another thing you could do, you could just talk to Dawn after, or you can go to safeharborstatelaw.com/schedule, and you can schedule right there a life and legacy session. And Dawn is well trained to do this meeting. If there's ever anything that needs attorney input, she just asks me, and we find that it works really well. So that is what I recommend. And then so you can go to our website now, safeharborstatelaw.com/schedule, or at the end here, you can give us your phone number, or we can have Dawn talk to you. And I'll answer questions at the end too, if you want. So here's my closing story. See the yellow canoe? That's what we had growing up. We had 8 kids in our family. I was the 5th. And so I don't know how my dad did it. I mean, he worked at Ham's Brewery as an engineer guy, and he they sent us all to Catholic schools and everything. And then we went camping. They bought a tent trailer and we had a yellow canoe. And that's what we did. And so we were out at Lake Rebecca one time camping. And my sister and I, Kathy, took off across the lake. And it was a nature area. So it was just like a dock and then like swamp. And she was in the back because, she was older than me. And we were pretty accomplished canoeists, actually. And so we took across the lake and it was a beautiful day. And we're like, oh, let's go all the way. So we go all the way across. And then we turn around and right away we realize, well, the wind was at our back. That's why it was so easy and fun. Now it's not. Plus a big storm was coming up. I mean, you know how in the summer, sometimes it can just come in so fast. And it was really dark and windy and scary. And so we're just trying to paddle back as fast as we can. And, like my chest is tight, my arms, and I'm worried about it. And, I still can't swim. That's my confession. So I always wear a life jacket, but I did not want to get dumped over in that, especially to turn the canoe over in the middle of that cold lake. So it was scary for me. Then I looked back at Kathy and she was scared. So now I'm more scared. And then I would just like you to think about this. I wish we were in person because you could tell me, but what do families do when they're under stress? Yes, we started arguing. So we're arguing anyway, and we're kind of going this and that way and trying to keep it straight. And it was really stressful, but we made it to the other side. And I was so glad. And in the future, I learned to plan ahead a little better and to pay attention and to not just like go as far as you can and then worry about coming back later. So I would like your experience and your loved one's experience with going through difficult times like sickness and passing in as smooth a way as possible. More like our trip across the lake that was enjoyable than the trip back, which was really stressful and caused arguments and strife. And that's why we're here, to make your life go smoother, even when the rough waters come up. So thank you very much for being here with us today. I'm really honored that you're here. And we'll stick around a little bit if you want to ask questions, if you want to talk to Dawn. Otherwise, we will get an email out to you. Watch for that. And we'll call and check in, make sure you got it. And, you can access it and you have all your questions answered.